Hello, everyone, and welcome to the Brooks Kushman webinar. During today's discussion, we will be reviewing and analyzing IP considerations that arise in common business transactions, including how to identify, address, and analyze key intellectual property issues in development agreements. If you have any questions, please type them into the chat box. We will be answering everyone's questions at the end of the webinar if we have time. In the days following the presentation, a recording of this webinar will be available on Brooks Kushman's website in the Media Center, as well as the slides for download. So let's get started.
All right, so I'm Matt Jakubowski. I'm a shareholder at Brooks Kushman. I've been practicing for almost 20 years in the Chemical and Mechanical Patent Prosecution Department, and I also draft and negotiate IP agreements, including development and license agreements.
And good afternoon. My name is John Leroy. I'm also a shareholder at BK. I've similarly been here a little more than 20 years. My focus historically has been software and electrical IP litigation, mostly patents and trade secrets. But over the last 10 years or so, I've focused more on open source software licensing and as well as standard essential patents and how they play into the supply chain and licensing. So we're going to jump into it. Before we do, I wanted to step back and talk about our perspective here. We're going to cover a lot of topics today. Some of you on this webinar may be more experienced with some than others, but hopefully there's something in it for everyone. But what I've tried to focus on are lessons learned through litigation over the years. In complex contract and IP litigation, typically involving software in my case, certain patterns have emerged. And we thought it would be beneficial to talk about things we've historically seen that have gone wrong and opportunities for improvement. We also draw from our experience in counseling our clients with joint development, custom development, and licensing agreements. So let's jump in. The first thing I want to talk about right from the top are what I think are some of the biggest opportunities for improvement. Virtually everyone on this call has some experience and typically in-depth experience with different aspects of IP law, but as I look back on the litigations, I see that there are things we could all potentially do better. And one of the most clear, again, for me, it arises predominantly in the context of software and electronics, is a bit of a disconnect between a corporate purchasing department and the IP department, where for years, and this is nobody's fault, but for years and years, purchasing departments have procured commodities, generally, pursuant to standard terms and conditions which have existed in many cases for decades. And they sort of have a routine, and they have a practice, and when they have questions, they will draw upon their IP counterparts, but what I've observed is sometimes they're unaware of the issues. They don't know exactly what questions to ask. And so in my experience, we could all benefit from a closer relationship between purchasing and the internal IP departments. In the software and electronics world, this arises in licensing, because we all know that software typically isn't sold, it's licensed, but as at least the local automotive market has evolved, many more of the commodity or component products that we historically have purchased now have software in them, licensed software, subject to unique terms and conditions and boilerplate provisions that, while the parties are in love and working together, are not a problem. But 5 years, 10 years down the road, when buyers switch suppliers and so on, we run into some roadblocks, some IP roadblocks. And I think some of these could have been avoided or at least minimized had the purchasing been familiar with the issues going in purchasing department. So we want to focus on some of that today. And one example of that we'll talk about is open source software licensing and how that impacts the purchasing and sales process. And finally, standard essential patent licensing. You know, at one level, standard essential patents have been around for a long time, and entities have been paying royalty fees for codecs, to via licensing and others for many years. But it's a new era now, as the Internet of Things has emerged, and especially in the automotive industry, as the cars are increasingly connected, we now have to deal with this standard essential patent issue and licensing on fair, reasonable, and non-discriminatory terms. So what does that all mean? And where are we? There's worldwide litigation on standard essential patents. It's evolving daily, as in last night, and so we're going to talk about some of that. So you'll have an understanding of what the latest and greatest is in that area. The second point we want to focus on is the management of intellectual property rights during a collaboration project. Collaborations today are happening way faster than they did 10 and 15 years ago. You know, when I started in this practice, you got a lot of advance notice that Company A and Company B were going to do something fantastic together. IP attorneys were involved because you had that amount of time to think about it and understand who was contributing what and where it was going to go, and it was a slower pace. Today, we learn about collaborations after a lot of the IP has exchanged hands in both directions, while the project is well underway and by the business or the engineering or development team, but the IP team's kind of just catching up. So that's one issue, is just the sheer pace of it all. But what I have observed in litigation that I think could help in custom development and joint development projects is an increased role by the IP lawyer, typically an in-house lawyer, in the ongoing relationship. So often we see IP lawyers only get involved in 2 points in one of these collaborations. At the beginning, when we're drafting the contract, and at the end, if and when there's any dispute, which we like to avoid. But what I think really needs to happen is during the project, and we'll talk more about this, have an IP lawyer participate, check in regularly, what have you, to understand what is the evolution of the developed IP, who owns what, who's getting licensed to what, and at the end of the day, plan for a amicable divorce, because not all relationships last forever in business, and that's really what today's presentation is about, is planning for the future. Another problem that has emerged that we'll spend a little more time on, and I have some sample language for you, is dealing with these improper designations of a proprietary nature during a joint development process. Sometimes these contracts and projects can last for many years, and over the course of those years, dozens of people will generate hundreds, thousands of pages of work product, and often innocently, they label them with their own company's propriety, either their logo, copyright notices, what have you, and they don't do it intentionally to interfere with intellectual property rights, but they do it. And so we want to talk about a mechanism for dealing with that problem, because if you don't deal with it and you find yourself in a dispute 10 years later, some of these designations can come back to bite you. And finally, we're going to address indemnification and warranty language, specific approaches, specific issues that arise. While indemnification and warranty provisions are a staple of all standard terms and conditions that many of us have dealt with for a very long time, they have to evolve. The products are evolving. The suppliers and sellers have more leverage because they're selling higher, more customized and specific functionality as opposed to historical commodity items. So we're noticing that there's a shift in some of that language and some modern negotiation, I guess I'll call it. Specifically talking about licensing as an element of purchasing, there are really 3 or 4 issues that I think purchasing areas where purchasing departments can benefit from IP education. And this is where you come in. Understanding that these are the 4 issues that I think you could enlighten or work with or focus on if your purchasing department is procuring technology that it has to license in as part of the purchase process. First off, software. When you buy a product, it includes or is accompanied by software that has software license terms and conditions. The ones that we find ourselves dealing with most in litigation a decade later is the fine print about use of data, reverse engineering, terms that, whatever they were meant to mean, are used as a lever to prevent a buyer from moving in a different direction. And while we're all going to respect one another's intellectual property, we also have to consider the reality that in the future, both parties may want to go in a different direction. And you want to be able to separate without fear of what I call arm-waving litigation. We can have meaningful debates about specific intellectual property, but we want to keep an eye on the boilerplate restrictions and software licenses that might impact our ability to either change a supplier, or, and that goes for both. It's not just from an OEM perspective. Suppliers have the same issues with their own Tier 2 suppliers and so on. So we got to think about that. Also, the presence of open source software. We could spend 2 hours on open source software alone, and some of you are very experienced in this, but the takeaway for those who are not is that, the adoption or utilization of open source products and technology that you distribute has obligations that you have to comply with and obligations that your customers have to comply with if they too are in the supply chain. We're going to talk more about that later, so I won't spend a lot of time on that now. But the other big ticket item are the patents to the standards bodies. And at the highest level, we'll have a situation where a purchasing department, not necessarily aware of the larger IP context, might agree as part of a purchase transaction to pay a particular royalty to a particular patent owner as part of a standards, that is part of a standards body. And that may be innocuous because it's a relatively small fee to a company. The problem is there's a larger context that the IP lawyer would be familiar with. We're going to talk about what that context is. And that one payment ends up setting a benchmark that can get used against the purchasing department, that company, in the future in litigation with other members of the standards body. We'll talk about that. This is a royalty stacking issue we have to deal with. And the takeaway is at the bottom. The biggest lesson learned is that we have to spend, IP lawyers have to spend more time with the purchasing department to understand and talk through these issues. And it's not a one-size-fits-all. How you approach some of these issues are obviously going to vary by your own identity and the technology that you're procuring. All right, getting more back to basics in terms of contract language. Joint or custom development projects, again, my experience is predominantly in the software space, but this will apply to really any joint development. Through the litigation, I've observed that while all contracts strive to address this issue, they're not all as comprehensive as they should be. Let's put it that way. And it's relatively easy to at least consider a comprehensive IP model for a joint development agreement. It may not be the model that you adopt because there's reasons you don't have to adopt some, you won't need some provisions, but it's something you want to consider. I have a model for you. But the first key opportunity is to recognize and accept that both parties are likely at some point in time to develop IP. You need to decide who's going to own it. It's got to be one party or the other. It's having both parties own it is a practical problem. The other party is going to receive a license, and we'll talk about a model for doing that. But you want to prepare for that and the divorce, that when this relationship is over, ensuring, imagine you want to procure substitute goods, substitute service from a substitute supplier, not infringing on anybody's intellectual property, but you want full freedom to shift gears and go in a different direction. You need to think about that when you draft the original agreement. Secondly, we've talked about this before, the IP lawyer ought to be involved as the project evolves, and not just at the beginning and not just when problems arise. That will help ensure that IP ends up, A, identified, and B, in the hands as it's supposed to as the relationship continues and you're amicably working together, and B, help police against some of these self-serving proprietary assertions. So here's a comprehensive model to consider. It starts off with what you each bring to the table as a negotiating party, licensee or licensor, a buyer or seller. You each have your own IP. That's not new. We call that background or pre-existing IP. The harder question is the circumstances under which your partner might need a license to your own background IP to practice whatever the heck they're developing for you. And you got to look at this from both sides. If you're the developer, you may need your customer's IP to be able to make and sell what you're trying to make and sell. And then when you get divorced and you go off and you're no longer doing business together, but you still have the fruits of your labor, you want to be able to sell them, use them, what have you. So both parties have to think about the extent to which they need the other party's background IP, limited rights to it, to be able to separate and continue to do business. And that is often overlooked. I put that in green. Then we have what we call foreground or developed IP. This is the new intellectual property that's developed as pursuant to the agreement. It's what the money is paid for. It's the fruits of the labor. There are three basic ownership scenarios. Either party A develops something completely on their own, but within the scope of the agreement. Party B develops something completely on their own, but with respect to the agreement, sort of the flip side of the first. Or finally, they just jointly do it. There's a whiteboard in the room, there's a table, they're sitting around it, and they're jointly coming up with IP. This happens all the time. And this, when litigation occurs 10 years later, it can be difficult to go back and unscramble the egg. But what's important from the IP perspective is that going in, we recognize there are at least these three scenarios. And what are we going to do about them? You don't have to memorialize all of these. You don't have to deal with all of them in the agreement. You don't even have to deal with it this way, but you do need to recognize there are at least three ways in which IP arises that can have very different approaches to licensing and ownership. You don't want to have thought about that, years down the road after the development is complete and we're fighting over who owns what in a separation, amicable or inamicable. Next, we need to consider all forms of IP and non-IP. So often I see contracts that are right up front about patents and copyrights, but we don't see any mention of trade secrets, what they are, how they're going to be managed, who's going to own them. Data is often overlooked. We can have a long debate about whether data is or is not a form of intellectual property, and reasonable minds can differ, but it exists. And I've been in litigations before where there's a fight over who owns the data when you separate. And so that's just something you want to think about and deal with up front. But equally as important is whatever you want to call non-IP, whatever's not a trade secret or patent or protected by statute or common law, whatever bucket you put that in, you call it a contribution. That has to be dealt with. And believe it or not, you'll have a scenario where you have something that's not protectable by any recognizable intellectual property law, but some other party will be telling you you can or can't use it. And you need to think about if you're a buyer and you issue things like requests for quote, lists of requirements, things of that nature that are full of information. They may not be conventional trade secrets or patent worthy, but they definitely are your contributions. You want to make sure you own them, and you'll be surprised years later as to what the fight might look like with respect to your own requirements. Because there's a difference between the what and the how. The what, which you often see in requirements, are the big ideas. Whose big idea was this anyhow? And then there's the how, which might be the supplied component. But you want to think about that when you're defining the IP in the management model. And the last bullet is the assignment issue. This is so often overlooked. If you're going to have a complex joint development or custom development relationship, you want an automatic, if you're a buyer, you want an automatic, and frankly, if you're a seller, you want to understand that you're going to have an automatic assignment or negotiate it. You don't want to, it's not good for either party to have a 3-year agreement, spend millions of dollars building some fantastic thing, and then spend 10 years trying to figure out, who owned what and who has what rights. It's something you want in your model going in. Be more transparent. Disputes will arise. But what's great about it, if you deal with it up front, is disputes will arise while you're in business together. And I can assure you that that's a much easier point in the relationship to resolve disputes than after the relationship is over. All right. The next slide, I put some sample language together. I didn't put it in quotes, but this is just some sample language to chew on. It's not legal advice, but it gives you a starting point. And I'm not going to read this all to you, but I do want to talk about, and I don't know if they can see my pointer or not, in the automatic assignment here, I talked about the need to consider an automatic assignment. It says, Party B hereby assigns to Party A, Party B's ownership rights. And I want to focus on the hereby assigns. That is an automatic present assignment, because I often see in these agreements, Party B agrees to assign. Okay, that is a completely different kind of provision. If you want automatic assignment, you have to have hereby assigns, because if Party B agrees to assign, but does not in fact assign, you've just traded a perfectly great intellectual property right for a perfectly great contract claim in some courtroom somewhere. So if you want automatic immediate assignment, it has to say hereby assigns, and agrees to assign is something in the future. It's the difference between equitable title to the intellectual property and legal title. It's a topic maybe for another day, but just I wanted to point that out in the language. The management of developed IP. I talked a little bit about this, and I know that all of the IP counsel on this phone call, they have lots of other things to do than sit around and sort of monitor complex projects on an ongoing basis. But I can tell you that a little bit of participation by an IP lawyer along the way, monthly, quarterly, annually, anything, is better than nothing. And I guarantee you that if any IP lawyer jumped in the middle of a joint development project about 3 months in and found out who's doing what and who's writing what where, he or she will have something to say. It'll be positive or negative, but practical guidance could be valuable there. And I think it's something that does not happen a lot. What I have seen happen, which is just not been particularly efficient nor remotely accurate, is to download to the management team or the developers the right to decide as software is written or as things are physically developed, who owns what. So they got this contract that has all these fantastic categories of IP ownership, and they leave it to the developers to put different things in the categories. Well, they're operating as best they can, but they don't really understand the implications. And the main implication I'm talking about is the divorce, when the relationship's over and the parties want to separate ways. An IP lawyer will appreciate that that's a little more complicated. Now, the IP lawyer can't do it on his or her own. He has to cooperate with the project team. As I said before, disputes will arise, but you're going to be far better off resolving them during the project and afterwards. And while you do it, and this is true with open source, while it can be painful the first couple of times to drag your developer, your project manager, through the painful experience of IP law, he or she will eventually get better at it. He or she will eventually be able to spot issues and raise issues with you in other projects. So there's a huge educational component to having sort of an ongoing relationship with your development team from the IP perspective. All right, common problem. You got a 3-year relationship. You disclose to the other party your wants and needs. They disclose to you the how-to, and both of you just create all kinds of PowerPoints and spreadsheets and specifications and documents and emails, and every email has this, little boilerplate at the bottom says, this is proprietary to my company or confidential or logos, and you just get this hodgepodge of materials with the wrong designations on them. This has happened in every IP case of trade secret style anyhow that I've had to deal with. And they're often innocent designations, most cases, not always, but generally they are. As I say here, you can try to prohibit them in the contract. I have some language on that. You can. But the developers aren't reading the contracts. You've got dozens of people potentially involved in this, and they are going to just make these designations. So you need a different solution, a supplementary solution. Because if you do nothing, and you allow your contracting partner to write on their documents that they own your stuff, and then you get a divorce, and there's a battle over who owns what, you're going to wish that you had some model in place to address that. Anyway, and it's a policing model. It's had through education and training and your personal involvement in these projects on some sort of ongoing basis. Anyway, I have some sample language here saying don't do it. It's the first sentence. And the second sentence says if you do it, it doesn't trump the contract provisions about who owns what, and it doesn't trump the contract provisions on the assignment obligations. So, All right, open source software. This, I know there are folks on this call that have a very in-depth experience with open source software and dealing with the issues in the supply chain. This is more for those of you who don't. But the bottom line is if you are contracting, buying, selling, or building anything with software in it, you need to understand open source licensing, and your purchasing people and your sales people need to understand it. Because if you have software, you have an open source issue. It's just a matter of degree as to how big or small it is and how you're doing. That's sort of the bad news, that you have an issue. The good news is it's relatively manageable. It's mostly about education. Analogize it to gasoline. We all need it. We all use it every single day. It's fantastic to get us where we want to be in the world. But if you don't handle it right, it can blow up in your face. Open source, kind of the same thing. Open source software is free software that your developers love. They get it off the internet. It's tried and true, and it makes your products less expensive and faster time to market. That's all the good news. The bad news, somebody else owns it, much like standard essential patents. And these, you don't have to pay a royalty rate, it's free, but you have these obligations. And what the obligations are depend on what license the software is subject to. There are hundreds of licenses. In the right-hand pie chart here, I've shown from WhiteSource the top 10 open source licenses in 2019. That was the title. So there they are. Your developers are probably familiar with these letters. They probably have virtually no understanding of what the contracts say, nor have they read them. And your obligations are all defined by them if you sell or distribute anything, including software. I've put some example obligations here. Again, today's not really an open source presentation. We can do that another time, I suppose, but understand these licenses exist. You have to read them. You have to comply with them. They can vary greatly, and if you ignore them completely, then you are facing a claim of copyright infringement, or at the very least breach of contract. This does occur in commercial litigation, but I don't want to hijack today's meeting to talk about that. It's just more of an awareness issue. On slide 12, first point is the starting point. A lot of your companies already have an open source policy to deal with what you can do, what you can't do. Sometimes they're internal policies that your IT department may have defined and managed. That's IT, that's not purchasing, right? Some of the more sophisticated companies in this space have very well-defined open source policies for purchasing and for development. So find that first. If it doesn't exist, it probably should if your company buys or sells anything with software. Having nothing is a problem. Without getting into great detail, these agreements policies either tell you what you can use, what you can't use. They tell you that if you want to use something that's in neither category, who do you call? What do you do? When do we disclose to our customer? How do we audit? Because you have to do these digital audits to get the right answer, and so on and so forth. So I don't want to get bogged down in open source, other than it's another point that your purchasing department and sales need to know about. Finally, standard essential patents. This is the sort of latest and greatest evolution in contract IP negotiations. Just to touch on standard essential patents, are the owners of these patents, I guess before they were divested, sat at the table to define what the 4G cellular standard that your cell phone uses. They defined how Wi-Fi will work in products so that we could have a standard. In exchange for their privilege to sit at the table and write those definitions, they had to agree to license their patents on fair, reasonable, and non-discriminatory terms. And the they, by the way, I have an example pie chart in the upper right-hand corner. That's who the they is for 4G cellular, which is every cell phone today. Collectively, there are over 90,000 patents declared essential to your ability to make a phone call over a 4G network, and those are the companies that own them. or at least did own them, and that is sort of an outline of the SEP world. Problems. What is the FRAND rate? These patent owners are allowed to charge adopters and their suppliers a FRAND rate, but what is it? Who should pay? There's a big debate over whether the big fish at the end of the supply chain who sells the big end most expensive product, whether they should pay the royalty, or whether the chip supplier who actually inputs the cellular telecommunication chip should pay. Obviously, those are two very different royalty bases, revenue bases, and they lead to a very different number. There's also the complicating factor. If you pay one slice of this pie, what impact does that have on all the others? Do you have to pay their pro rata share? If you pay one, will you be stuck in litigation with the other? You know, it's very complicated. And then what happens if we don't reach agreement? What happens next? Well, we're going to talk about that because lots of companies have not reached agreement and they're fighting about it. For context, these license demands are high. Your average 4G chipset is $15 to $25 range. That's how much it costs for the microchip to make a phone call, at least at the modem level. But the license fee demands exceed that. So you're paying right here, or at least the demands, are 100% royalty rate and higher. And most buyers consider that remarkably high. So that's the putting the bookends, I guess, around the standard essential patent issues. Also, while we're used to buying things subject to warranties and indemnification, when it comes to modems and wireless technology, the suppliers refuse to do so, have refused to do so for a decade or more, and there's no end in sight on that front. So that means the folks farther down the supply chain have to deal with the issue. Real quick, the Nokia litigation is probably, there are a couple of hot litigations in the SEP licensing world. Nokia is probably the hottest. This is a calendar just this month. We had a complaint in Europe, an antitrust complaint filed in the European Union against Nokia by Daimler. Nokia responded fairly aggressively, filing 10 lawsuits against Daimler in 3 different courts in Germany. First one to trial is going to be mid-2020. That's fast. That's faster than anything you get in the United States. Continental got involved because they're a Daimler supplier. They filed a lawsuit against Nokia and Avanci. Avanci is one of the primary standard essential patent brokers. They filed that complaint in May of this year. Trial is recently scheduled for 2022, so as you can see right there, American court's going to get to this issue quite a while after the German court resolves at least the first part of the debate. And then the next 3 bullets are one party trying to tell the other party that it can't continue in the litigation, that the litigation should be here or there. I don't want to, it's all right here. But the bottom line is, it looks as though neither court in Germany nor court in the U.S. is taking their foot off the gas on the merits of the litigation. Also, neither court has prevented the other court from doing so. I take that back a little bit. I don't want to get bogged down in it. But in any event, both the American court is proceeding on the merits for trial in February 2022, and we'll see our first decisions out of Germany in the summer of next year. And hopefully we'll get some guidance. The other major wireless licensing litigation is the FTC versus Qualcomm. This is a complaint the FTC filed in California. Nokia had a variety of licensing policies that the court ultimately frowned upon in a May decision this year. It's 233 pages, so any of you that have read a district judge's decision will realize very quickly that that's a long, thoughtful analysis. You could agree or disagree with it, but it's thorough, if nothing else. And all those bullets there are actually quotes from specific things that the court ordered Qualcomm to do, ranging from go back and renegotiate all of its, or not all of its, many of its license rates and report its progress. Qualcomm appealed, no big surprise. They raised a couple of points. They're listed there. And the Ninth Circuit granted a stay on these orders that I've listed there pending the appeal. And the Ninth Circuit's hearing is set for January. Not too far off, so we'll get some guidance. Well, we'll get some guidance after that, probably summer of next year on Qualcomm's products. So that wraps up. I'm going to pass the baton to Mr. Jakubowski, but thank you for the opportunity to share some of this with you.
Thank you very much, Mr. Leroy. As you mentioned during your presentation, there's been a paradigm shift with respect to these supply chain relationships where historically it's been more commodity driven, and because of that, there may not have been so much homage paid to certain provisions of these development agreements and of the overriding an existing master service agreement or global terms and conditions, because there was a lot of IP that was associated with the commodity supply relationship. You fast forward to more modern times, we're looking at a more collaborative paradigm where the supplier and the purchaser are collaborating, and part of that collaboration is the supplier using its expertise and know-how, and because they often provide unique solutions, they often have more leverage than they have in the past to try to strike a balance between broad IP indemnification and narrower IP indemnification that takes into account the factual relationship of the parties. So that's some backdrop for me drilling down in the details, the nuts and bolts of several different provisions that you see in these types of agreements, and bringing to bear lessons that I've learned through drafting and negotiating these agreements. We're not taking one side or the other when it comes to what the right language is. It's more so identifying issues that may have to be addressed during negotiation and drafting of the agreement. And by looking at these issues, the takeaway would be to draft clear language in the agreement to avoid future litigation because you know exactly what the parties negotiate and bargain for. And this could avoid a controversy in the future if a purchaser explains to a supplier that, hey, you're on the hook to indemnify for an allegation of intellectual property infringement. If the language is clear, it could avoid confusion as to whether there's an obligation to indemnify there, and that'll be helpful to both parties. So here's a version of a standard broad IP indemnification provision. I won't read the entire clause, but towards the end, it relates to any infringement or misappropriation of any intellectual property right relating to the delivered products and or services. I've highlighted two of the phrases here. The relating to language is quite broad, and sometimes it's subject to negotiation, whether, under the circumstances of the business relationship, whether arising under is a better term to use, as it focuses more so on what actual intellectual property rights are at play and the delivered products and services. So that's more of an issue spotting concern as to whether it makes sense to use relating to or arising under. With respect to the other highlight, products and or services, that's usually subject to a definition in a master service agreement or global terms and conditions or a specific development agreement. It's important to understand what the definition is, and it's typically set forth in the first or second page of the agreement, but then you get down to the intellectual property indemnification section, which is buried towards the end of the agreement, but you want to make sure what the scope is of those products and services to make sure that it fits into the IP indemnification provision. Now, from the standpoint of the provider of the deliverables, the products or services, there's some exceptions that should be considered, and in that consideration, they're subject to negotiation of the parties. One of the exceptions to consider are whether specifically designed products and services in accordance with the buyer's specifications should be accepted from the scope of the intellectual property indemnification. The reason being, the justification is that if the buyer is speccing the products, then it's the buyer who should be responsible for any intellectual property allegation of infringement that results from that. And another exception to consider and discuss is a modification of the deliverable by the buyer after it's delivered. In that case, that modification may be the premise, the basis for the allegation of infringement, and because of that, it's something that should be considered and discussed by the parties during negotiation to understand in the grand scheme of things the overall contractual relationship and in what each party is getting out of it, what risks should each party have. And it's a lot easier to have these discussions during drafting negotiation than down the line when one party wants the other party to indemnify and the other party says, no, I'm not willing to indemnify, and then you get into an issue with respect to the scope of this indemnification provision. So another exception to consider is whether the deliverable is combined with other third-party products or services or materials. This comes up quite often with respect to software, where your software vendor may be implementing a small piece of an overall software suite. It could be an accounting suite where the vendor's only developing one module, and that module is going to be put into the suite of products. So with respect to that issue, it's another one that should be discussed in the context of negotiating an agreement and getting the right language on paper with respect to these types of provisions. And then the last one's a non-intended use, whether after the buyer takes the deliverables, they use it in a manner that's not intended in accordance with the development agreement. In doing so, it may be something that shouldn't be indemnified, or if it's going to be indemnified, try to hash it out in the agreement to avoid any potential issues in the future. And there's a resistance to adopting any of these exceptions on behalf of some purchasers. And one of the areas, the pressure points, is what these types of exceptions, to apply them would be contingent on future facts. But in many instances, they're contingent on future facts anyways, because there's allegations of infringement that would have to be resolved and figure out what the scope is, even if you have a broad indemnification provision. And then in other instances, the argument will be made that you should err on the side of the broad indemnification language, so there isn't any issue in the future as to how you construe these exceptions and what the scope of the exceptions are. But the reality of the situation is this is becoming a more prevalent issue for purchasers because of the paradigm shift away from commodity to customization. So it's an issue, at least in our experience, that you're going to be looking at a lot more, and we want to at least identify these issues for consideration. Now, we just went through the exceptions, and then there's the exceptions to the exceptions. This could be the pushback that's made by the purchaser, where it appears that the exception may be too broad. With respect to the first one, a specifically designed product in accordance with the buyer's specifications, you'd want to ensure that specifically designed product is what's required for the allegation of infringement or misappropriation. So if there's something else that gives basis or the premise for the allegation of infringement, then maybe that should be outside the scope of the exception. So there's some proposed language in there to address that exception to the exception. Another one worthy of discussion is a modification. It's the nature of the beast that since these relationships are so complicated and complex, it's very uncommon to have the deliverable implemented on a standalone basis. It's going to be modified for purposes of the buyer purchaser's business. So because of that reality, an exception to consider is that if there's modification that's made by the buyer, then only in those instances where that alleged infringement requires that modification made by the buyer is a situation where infringement indemnification is not an obligation on behalf of the seller of the product or service. And with respect to the last two, it's the combined use of deliverable with third-party products or services. This is an area where I think we've both discussed during this presentation, this webinar, that in the software context, it's very legitimate and foreseeable that there's going to be a combination with whatever the software deliverable is with a bigger software system and how it plugs into the purchaser's overall system. So what makes sense is to understand what is reasonably foreseeable with respect to this combination, and it may take some drafting and some specifics to identify in the agreement, but you'd want to identify those specifics so these foreseeable combinations would still potentially fall under the obligation to indemnify due to IP infringement. And then with respect to non-intended uses, this exception to the exceptions, more of a belt and suspenders look at it. So the non-intended use and the exceptions defined as not in accordance with, but it would also be worthy of discussion as to whether it should be added that if there's a non-foreseeable use, in addition to it not being in accordance with the development agreement, then that exception would apply. Now here's another area where it's very parallel in application to the intellectual property indemnification obligations that you see in these types of agreements. There's always also a section that identifies several different representations and warranties that each party makes, and then usually in a development agreement, the party that's supplying the product has a greater number of representations and warranties in connection with the agreement than the buyer does. And buried in that representation and warranty section is usually a very, very broad non-infringement representation and warranty where the seller represents and warrants that products and or services will not infringe any intellectual property rights of any third party. With this broad non-infringement rep and warranty, if there's ever a violation of the rep and warranty, this typically triggers the overall general indemnification obligation, so you basically end up in the same spot as you would if there's broad IP indemnification language in the agreement. So this is another area to consider. In my experience, I've seen situations where changes are made to one section and not the other, and it could be a gotcha. So it's two areas that you want to make sure to highlight and negotiate and get down to language that both parties appreciate and agree to. And the takeaway is the same as with the other sections relating to the indemnification obligation on IP, is if you have clear language that's negotiated, you could avoid satellite litigation as to whether the obligation has been triggered to indemnify, as well as having to defend a lawsuit relating to the IP in the deliverable. So we already mentioned this. The exceptions are very similar. It's the specifically designed products, the modifications of the products, combinations of the products, as well as non-intended use. So it's essentially the same checklist you look at with respect to the other type of section. Now, shifting focus away from development agreements and master services agreements, we're looking at the standalone non-disclosure agreement, which is typically the first step in the process right before there's an MSA signed or there's a specific development agreement that's negotiated and signed under an MSA, and obviously everybody that's listening in here has their template, their standard drafts of NDAs, reciprocal NDAs, one-way NDAs. But we want to highlight some practical issues here that many of you may have considered already, but others may not have, and will provide some value to at least some of the audience. Is one question is who can sign and who can edit the NDA? Many times you have purchasing and engineering involved in sending an NDA out to the other side, and they have authority to sign it. But when it comes to making edits and accepting edits, it could be a difficult and precarious position for the non-legal personnel to be in, because they may not understand the impact of any changes that are proposed in that NDA. So from a process procedural standpoint, it would make sense to have purchasing and engineering and other non-legal personnel understand that any proposed edits should be approved by legal, so that legal can understand if there's any far-ranging consequences of the edits that are being proposed. Another area for discussions, designate or not to designate when it comes to documents that contain confidential information. In many of these NDAs, there's a requirement that you must designate the documents as confidential to maintain the confidential status. This sounds good conceptually when you're reading the language. Yeah, this makes sense. But as a practical matter, throughout the life of the project, it may be very difficult to maintain this obligation. And then if you designate on some documents and not others, does that raise an issue as to the confidential status of those documents that are not marked appropriately according to the non-disclosure agreement. Another area here where you could get into trouble with a designation obligation is this could have consequences on IP status and ownership of the documents that are being marked or not being marked. So again, it's another reason to support not having such a designation obligation, as it's very difficult to adhere to through the life of the agreement. Another topic here for NDAs, one-way or mutual. Sometimes the assumption that a mutual NDA is necessary may be incorrect, so it's always good to have two different versions of your NDA. Some cases, there may only be one disclosing party and one recipient. In those cases, from a factual standpoint, it's probably better to have a one-way NDA at that point in time. And then the last topic we want to bring up is the fuse that could blow up your trade secret status on termination of the NDA. One of the requirements of trade secret is that the information is subject to efforts that are reasonable under the circumstances to maintain the secrecy of the trade secret. NDAs typically have language that at some point in time after termination, the agreement, the obligations shall terminate. This at least brings up the question as to whether the existing obligations with respect to what was disclosed in the agreement are subject to continued obligations of confidentiality. To resolve that issue, what we propose doing is considering express language to confirm trade secret status. So notwithstanding any obligations regarding confidential information constituting trade secrets shall survive the termination and expiration of the NDA. So at least then you have that placeholder there where the argument is disarmed, and you may have disarmed the fuse with respect to potentially destroying the trade secret status of certain confidential information. And this one, real quickly, we're running out of time. Covenants not to compete. You see this more and more often as part of the modern trend that in the IP sections of MSAs and other governing agreements between parties is that there's a broad-ranging covenant not to compete. And we've seen it where it's not limited to IP. Sometimes it's not limited to the products that are being supplied under the agreement. It's just very broadly states that you're not going to compete with me. If to the untrained eye you don't see that language and highlighted and make it of appropriate scope, it could be very, very broad in application and could lead to increased risk for litigation, giving a claim to breach of contract if the covenant's not abided by. So to spot that issue and then understand, well, what makes sense? Is there a durational period that makes sense, a head start, maybe 6 months where there's no competition, then after that the supplier can compete because the supplier has other business opportunities, and as long as they do that without the IP that's associated with the development agreement that the purchaser has rights to or ownership of, then maybe that's a common ground that the parties can reach, and that has to do with the scoping issue. You may be able to have a covenant not to compete, but it may not have to be so broad that it swallows the entire relationship between the parties. And if it's appropriately scoped, many times you don't need a covenant not to enforce because you've identified in the IP ownership provisions, the licensing provisions, the indemnification provisions, what the obligations of the parties should be, and it's done in more specific fashion, and it's probably better suited for those provisions than a covenant not to compete provision. So with this slide, it concludes my portion of the presentation, and we have 2 minutes left, so not a lot of time for questions, but we have one question here, and this one's for Mr. Leroy.
So the question is, what's your position on OEMs requiring suppliers to place an OEM proprietary notice on all released prints? Well, it seems like that is if you're the buyer, if you're the OEM, that's definitely a fair request. It's not without challenges if, in the end, if I understand the question correctly, the suppliers are, obviously if the suppliers are providing innovation to meet the RFQ and to supply the product, and that innovation is reflected in the OEM prints, then that supplier may take issue with it. But it's one approach an OEM may take, and if there's a dispute over whether that's appropriate, because those prints ultimately will capture the entirety of what is delivered in the physical sense. The prints don't necessarily capture the electronics and software, which may have other issues. But that would be a broad brush approach to confirming that OEMs own everything, but the suppliers may have a different view of that, of course. So I'm not sure if I fully understand the question. That is definitely one approach to consider. That could make sense.
Okay, and with that, thank you all for listening to our webinar today. A recording of the webinar as well as downloadable PDFs of the slides will be available on Brooks Kushman's website in the Media Center in the coming days. Please feel free to contact either John or Matt if you have any further questions, and we look forward to hosting another webinar for you soon.